CRJ 227, this is your podcast for week number 3 for the summer course. I'd ask you to do some reading. If you did the reading, what I'm going to say makes sense. In week 3, you know that you need to do the reading for what I'm going to say makes sense. And if you're not doing both the reading and trying to give your best attention to what I'm saying, you're going to struggle picking things up. But it's really good stuff. So, on October 31st, 1963, about a little less than 50 weeks before I hit this earth, while on routine patrol through downtown Cleveland, Ohio, Cleveland Police Detective Martin McFadden, a 39-year veteran of the police force, noticed 3 men acting suspiciously and pacing in front of a jewelry store. He was concerned that the men were casing a job, going to have a stick-up, and that they may be carrying weapons. Now remember, 39 years of experience. That's going to be relevant to this discussion, but also just what he observed, the location, the circumstances, etc. He identified himself as a police officer and asked for names. When the men only mumbled something in response, he frisked them and found a pistol on John Terry's overcoat pocket and a revolver in Richard Chilton's coat pocket. The third man was unarmed. He arrested and charged Terry and Chilton with carrying concealed weapons. The men were found guilty, and the trial judge ruled that given the suspicious nature of their behavior and McFadden's concern for his safety, the decision to frisk was permissible. On appeal, the trial judge was affirmed, and then John Terry, appealed to the U.S. Supreme Court in 1967. Now this became known as the stop and frisk case. Provides the basis for stop and frisk and everything that's evolved since. The case is Terry versus Ohio, case I asked you to read. And it represents a conflict between the Fourth Amendment protection from intrusive, harassing conduct by the police when no crime has been committed and the duty of a police officer to investigate suspicious behavior in order to protect the public and prevent crime. Tries to balance those things out. In June of 1968, the United States Supreme Court affirmed the conviction and set a precedent that allows police officers to interrogate and frisk suspicious individuals without probable cause for an arrest. The court provided that if the officer can articulate a reasonable basis for the stop and frisk, that's okay. Now, to be clear, Terry does not provide a blanket authority to interfere with an individual's right to be left alone, nor does it allow such an inference or interference based on the police officer's hunch that a crime is about to occur or is in progress. However, Terry did radically expand police authority to investigate crimes when there is a reasonable basis for suspicion. Now, we'll break that down, but remember what I said a few minutes ago. Officer McFadden had 39 years experience as a police officer. Officer McFadden was on foot patrol in downtown Cleveland And outside a jewelry store, he sees 3 men looking suspicious. Just by their nature, what they were doing, what they're looking in the window of the jewelry store, kind of looking around. They didn't look like they were waiting on a bus. That they had any business kind of looking around and inside and around the jewelry store. Something caused him to have a reasonable basis for suspicion. Keep that in mind. And let's break down the expectations of the law from the general encounter between the police and citizens all the way to arrest. Let's talk about general encounter and questions by the police. Even without suspicion of wrongdoing, a police officer can approach someone and begin a conversation without violating the individual's Fourth Amendment rights, as long as the individual reasonably feels free to end the discussion and walk away from the officer. The officer's done nothing wrong. And let's face it, successful police officers are comfortable approaching and having conversations with people regardless of suspicion of wrongdoing. We want police to talk to people. It's probably one of the things that doesn't occur often enough, and there's a whole lot of reasons for that, and that's for somebody else's course. But you know what goes on in the world. We also want and need citizens to be comfortable and confident in approaching you, if you're going into policing and want to be a police officers, right? That's the best of all worlds. So police can come up and talk to you. They can come up and talk to anyone. You don't have to talk to them if you feel they're being intrusive, but there's a balance there, right? There's a balance there. And hopefully someday, probably in your career, hopefully someday very quickly, we get back to that expectation. All right, so let's talk about the investigatory detention or stop. That's the next level of police interaction, an investigatory detention or stop, which should be a brief circumstance, only long enough for the officer to assess the situation. So in this stop or detain time period, in order to stop or detain someone, the police must have a reasonable suspicion of criminal activity. That is, an objectively reasonable basis to suspect that the detainee is or was involved in a crime. Now, it doesn't say you have to know. It says that you have to have a reasonable suspicion, that you have to have an objectively reasonably basis to suspect. To suspect. We've all been suspected of doing things we didn't do, and those things were investigated by our parents, by teachers, whatever, right? It's something that happens in our day-to-day interactions. Now, essentially, it's more than a hunch or distrust, and that's what is expected of police. So you have to have facts that show this reasonable basis to suspect. The classic example that was always given, that I remember from, my time taking this course. It's you're on patrol at 3 a.m. on a warm summer night in a residential neighborhood that has experienced a number of recent burglaries. The officer sees a man walking up a quiet street. The man's wearing black pants and a black long-sleeve shirt. Remember, it's summertime, it's warm out. This stop, the officer stops the individual to talk to him, and this stop isn't a full-blown arrest. Rather, it's an interaction in which the citizen isn't necessarily accused of a crime, but also isn't free to leave, at least until the officer indicates otherwise. So, in this scenario, the officer pulls over, asks the man to stop, asks for his name, asks where he's going, where he's coming from. The man gives his name. So he's going home to an address that's the next street down, and he's coming from work as a waiter at a fancy restaurant a mile or so away. The officer knows the restaurant, knows that the waiters and staff dress just like this man. The officer knows the neighborhood and knows the address sounds right. Now, the officer could and probably does, and I probably would ask the man for ID to verify the address, and if it checks out, the officer tells the man to be safe, warns him about the burglaries, thanks him for his time. End of encounter. If the circumstances presented are a bit different, the man's hesitant or appears nervous, he doesn't provide the same type of plausible response as to where he's going and where he's coming from, the officer is likely to move to the stop and frisk, making a mental note as to whether backup was close, right? Have you called to let people know where you're at? And what's been the response? Is another car on its way? Is another officer on its way? Because as you'll find out in training, and I would hold to it, sometimes you have to take a deep breath. And you don't want to put yourself or the other person in a predicament where their safety or your safety, especially your ability to do your job, is put at risk. So if that's the case, take a pause, kind of let things play out, wait for your backup. In any event, on the stop and frisk. So now we move to the stop and frisk. Even if police have reasonable suspicion to briefly stop someone, the officer can't frisk a detained suspect without reasonable suspicion existing to believe that the person is armed and dangerous. So those changes in circumstances, somebody's not being forthcoming, they're being hesitant, they're trying to be less than cooperative. If you stop them, you're always going to want to pat them down for your safety, especially in today's world. You want to be really careful and follow your training on this and really get into your training on this. Don't take that, especially the physical aspects. This is just a word of advice. A lot of things you do and a lot of things are based on your mental discretion, on your mind making a decision. But there's usually an action that comes with that people tend to take for granted. And those actions are physical in nature. And you have to practice those actions. Placing somebody under arrest, putting handcuffs on someone, is something you should practice doing it. Do it the same way every time. Do it as you're trained. Do it so you and they stay safe. Okay? Just a word of advice right there. But for that reason, an officer can pat down the suspect's outer clothing in a search for weapons. If the officer happens to find contraband, like something that might be a burglary tool, when they're conducting that limited pat down for weapons, that seizure will usually be found valid. And I say usually because, again, that's not our decision, it's the court's. We just do what we do and record it and do a great report, and then eventually it's going to be up to the court at some point. In this scenario, the officer moves the detention to an arrest by further restricting the suspect's freedom by, for instance, using handcuffs or placing the suspect in the rear of the patrol vehicle. So let's talk about arrest a little bit. An officer can arrest someone with either a warrant or probable cause to believe that the person's committed a crime. Remember, probable cause is more than reasonable suspicion. Reasonable suspicion is what you needed in order to get to this stage, right? Now it goes up a notch, the probable cause. And what gives you that probable cause? We found the burglary tool. You have the history of the burglaries in the area. You have the inability of the person to explain where they came from, where they're going, or anything that was plausible as to why they're in the area they're at, wearing dark clothes, etc. So based on the neighborhood burglaries and finding the burglary tools in the pocket of the suspect and the pat-down, the circumstances lead to the probable cause. After the arrest, the officer can search the suspect and the immediate surroundings, including, let's say, a backpack that the suspect dropped on the ground when initially stopped. Sometimes they toss it. A person doesn't need to be in handcuffs and brought to jail for an arrest to occur. If it's clear to the person that he or she is not free to go, an arrest has likely occurred. And those circumstances could be putting them in the back of the squad car, which they can't get out of if it's a properly set up squad car, right? There's a cage and they can't open the doors once they're put in. But it could also be there's cases where someone is told to sit on the curb, and when told or asked if they could leave, no, you cannot. Okay? Now, generally, when we're talking about arrested or detained, if a reasonable person wouldn't feel free to leave an encounter with the police, then there's been a detention or an arrest. If a reasonable person wouldn't feel free to leave an encounter with the police, then there has been a detention or an arrest. Now, determining which can be tough, and sometimes it's crucial to determine which, but the facts are going to tell us this, and you're going to see that in cases. Sometimes it's clear someone is under arrest. For instance, when the officer specifically says so, no, you're not free to leave, and then handcuffs the person. But not all situations are that clear, because it can mean the difference between incriminating evidence being admitted or not in a case. A judge may have to decide, and they'll do that on the following factors. So scope of the restraint, the time, was it brief or significant? Time is something, if you take my 230 class or my 227 class, we talk about time. In self-defense, we talked about time. Time is always an element in the law. So what's the scope of the restraint? Was it brief or significant? An officer's brief and cursory holding and questioning of someone is a detention. An example is a police officer stopping someone who is behaving suspiciously in order to ask a few questions. The suspect isn't free to leave, but he also isn't under arrest, at least until the officer develops probable cause or believes there's probable cause. Another common example is an officer pulling over a vehicle for some kind of traffic or equipment violation, which we'll talk about in a little bit. An arrest, on the other hand, involves the police taking someone into custody through a more significant restraint or movement. The quintessential example involves the use of handcuffs and advisement that the suspect's under arrest, which should come also with Miranda. Pull your little card out, department-issued card, read it every time. And now that you're going to be videoed in everything you do, I mean, I say this to people all the time, officers all the time, that was something that was actually mandated, and a lot of people did that before video. But, somebody says that they didn't have Miranda, but you pull out that department-issued card and you're on camera, like it goes to the jury for some reason, or they raise that issue. It's not your word against theirs. It's on TV. As I said, the length of the stop, was it short or prolonged? Investigatory stops or detentions must be no longer than is necessary for the officers to investigate with the least intrusive means that are reasonably available. When the officer prolongs a detention beyond what is brief and cursory and broadens it, then the detention may turn into a de facto arrest. That is, an actual but not official arrest. If a reasonable person in the suspect's position would have considered the officer's behavior to constitute the kind of restraint that's typical of formal arrest, then the arrest has occurred. Some courts phrase the issue as depending on whether, after a brief questioning, a reasonable innocent person would have felt free to leave. Those are the words, free to leave. If they didn't feel free to leave, there's been an arrest. Now, how that happens is the court says, under these circumstances, I don't think it's reasonable that the reasonable person would feel free to leave. We always, again, we talk about the reasonable person all throughout the law as well. Factors that indicate detention turned into an arrest: the amount of force the police use, the need to use force, the number of officers involved, the manner in which officers physically handled the suspect, including the use of handcuffs, and the length of the stop. So guidance to avoid civil rights litigation, evidence suppression, and public criticism, and to keep investigative detentions lawful. Here's some constitutional points of law, and I will include the citations in my post for this week. Just some guidance. Number 1, officers may approach in public places and attempt to engage the public in conversation without suspicion that they may be involved in criminal activity. And again, have conversations with people in the public. Not everybody's involved in criminal activity. If you only try to engage people you believe are involved in criminal activity, well, then everybody you talk to is a potential criminal. That's not the way the world works, and it's not good for you and you being able to do your job, and it's not good for the people to feel confident in what we take an oath to do, right? So do that. Have conversations with people. And then over time, you learn when things are suspicious or not. You also get better at, ferreting out those suspicious things because you're good at approaching and talking to people. Number 2, the person approached without reasonable suspicion is not required to speak with the officer, produce identification, or otherwise remain in the area. The person may simply walk away, and the officer has no right to detain them. So the facts need to show, that it's more than a mere encounter. Number 3, officers who possess a reasonable suspicion that a person may be involved in criminal activity have a constitutional right to stop and detain, to seize that person for a reasonable period of time, the time necessary to investigate the situation further. Again, a reasonable period of time to investigate the situation further. Facts are important. And if you had me for other classes, you know that I say that often, but the facts of the circumstance. So head on a swivel, eyes open, and be taking in the facts. Reasonable suspicion, number 4, is present when an officer has articulable facts and reasonable inferences drawn from those facts that indicate that criminal activity may be present. Go back to the facts of Terry. And I cite a case in my comments that I'll provide to this week's assignment that'll extrapolate that out a little bit, so read those comments. Number 5, reasonable suspicion can include a number of separate factors that, when taken together, combine to support a police officer's belief that criminal activity may be occurring. These factors may include, but are not limited to, the time of day. Think about the example I gave you of the burglar. Reputation of the geographical area. Is it an area that may be prone to crime? Or is it that time, that neighborhood that was experiencing burglaries? Reputation of the person to be detained. Furtive or evasive behavior. Type of behavior that Detective McFadden noted in Terry. Flight, they take off. You go to approach them to find out who they are and what's going on, and they run. Well, that that's an indicator that helps go to reasonable suspicion. People that have nothing to hide don't run from the police. They have a confrontational or abrasive attitude, which, that's something that we have to work towards on our side to get away from or back to where we don't have as much confrontation. But that's something you're going to have to deal with. I'm going to a webinar today about contempt of cop. An officer who detains a citizen for investigative purposes has to be prepared to recite all of the reasons as to why he or she detained the suspect and should make a written record of them as soon as practicable. And, you're going to have it videoed for you one way or another. Be able to articulate. Be able to back up your actions, your choices, your discretion, your decisions. You have to do that on everything you do in law and justice. Number 7, investigative detention should take place and continue at the location where the stop was initiated absent extraordinary circumstances. Moving the suspect to the police station or the back seat of the patrol car or other location against his or her will very likely be construed as an arrest. Number 8, the officer must understand that an arrest under the Fourth Amendment must be justified by the higher standard of probable cause. Number 9, officers who have reasonable suspicion to stop and detain a suspect have the lawful right to maintain that detention for a reasonable period of time so long as they diligently pursue an investigation to resolve the reason of the stop. Diligently. There's a whole bunch of cases out about waiting for the dog to come out to the car when you believe that the person is transporting narcotics, but you can't find the narcotics in view, and you can't go in the trunk, and you don't have any reason to search the car or tear the car apart, but you're certain of it, and you know that the dog's going to hit. Well, if the dog's not immediately available, there's cases that say that, now it's not just a stop. So be careful. Number 10, officers may not detain a person longer than the time required to reasonably investigate the purpose of the stop. Holding a person for a longer period of time is likely to be interpreted as an arrest. Number 11, officers conducting a Terry stop, including a routine traffic stop, are not required to provide the detained individual with Miranda warnings upon or prior to asking questions. This is a stop, no Miranda. It's an arrest, Miranda. You don't have, we'll cover that later in the class. Officers who detain a person for investigation based upon reasonable suspicion that criminal activity may be afoot are not permitted to frisk that person detained unless they possess reasonable fear for their safety. And again, circumstances, reasonable fear for their safety. What are the circumstances? The circumstance of the initial burglary, you stop the person, they tell you they live in the neighborhood, the address says they live in the neighborhood, they give you a plausible excuse for coming through the neighborhood, all that stuff. You're not going to frisk that individual. Number 13, a frisk of a detained person must be limited to a pat-down of the person's outer clothing for weapons only. A search for evidence of criminal activity is not permitted. But that doesn't mean that in a burglary situation that you pat down their pocket and you feel something in there, you can't extract that thing, and then you find out it's a burglary tool. You don't know if it's a weapon or not, if it's a sharp object, etc. And number 14, officers making a Terry stop of a vehicle may conduct a search of the passenger compartment of the vehicle to look for weapons as long as they possess reasonable fear that the weapons may be hidden in the passenger compartment, where the people could reach to, not including locked areas. Now, while this week covers many topics related to stop and arrest, I want to spend a little time talking about vehicle stops. It's the nature of modern policing that police operate out of a vehicle for the most part. And if you think about the facts, especially in this region, right? Nobody would walk in a foot patrol or a foot beat unless it's in Peoria Heights on the weekend in the summer. If you think about the facts of Terry, the circumstances were better served by an officer on foot. Vehicle stops are a unique circumstance in a way, and not so unique in others. The majority of vehicle stops come with probable cause to stop. Some sort of traffic violation witnessed by the officer. In most cases today, those violations, if moving, can be recorded. The dash cam of the officer's vehicle records a lot of those things. Sometimes, too many times for my ability to drive peacefully, the probable cause comes from the officer knowing the driver and suspecting and then confirming the driver still doesn't have a driver's license. In any event, in most vehicle stops, it's something above reasonable suspicion. At that point, the stop results either in a citation, a warning, or a ticket, or further investigation leads to probable cause to arrest. If there's probable cause to arrest, we move to issues we will cover in this course later, but we really cover in greater detail in the evidence course. We'll talk about search and seizure, but that's what evidence is all about. I mean, we're talking about these issues in the 230 course, and if you had the 230 course, you know what I'm talking about. But additionally, if the stop leads to an arrest, the driver is taken into custody, the vehicle may be impounded. And that's the case in most local municipalities. Under Illinois law, a car or vehicle in any municipality may be impounded for the following reasons: used to commit a crime with the owner's consent, used for a sex offense, abandoned or stolen or unattended, DUI arrest, obstructing the highway or creating a hazard, driving on a suspended, revoked license, or without proof of insurance. If you're driving without proof of insurance, your vehicle can be impounded. Under those ordinances, the owner of the vehicle is subject to a fine, typically $500, storage and towing, the vehicle towing fee and storage fee. The owner may request a hearing under the preponderance of the evidence standard. And that's what the standard is in those cases. It's not beyond a reasonable doubt. It's the lowest standard behind our preponderance of the evidence. The fine, which has been stayed around $500. Finally, it's probably searched. Owner's consent, when we mean the owner allowed the vehicle to be used by an individual or someone else who exercised control of the vehicle with the owner's consent. In other words, the vehicle was not stolen. A lot of people come into those situations, especially when somebody's using their vehicle to commit a crime. So I did not give them permission to take my car. But the person's their boyfriend or girlfriend or living with them or has access to the car, regularly uses the car, etc. Sometimes they know the person doesn't have a license, but they don't stop them from driving. If you didn't report that vehicle stolen, you're on the hook. The intent of those ordinances, the public policy, is to cause vehicle owners to be responsible for their vehicles and people they allow to operate the vehicles. The point here is that in our region, because we are so spread out, public transportation is not the greatest, and vehicles are almost a necessity to live, lots of things happen in vehicles. Lots of things. If you're going to pull over a vehicle, make sure you have the violation. Make sure there's some violation, some reasonable violation. And it's especially great when that's on your dash cam. I've had cases, I used to hear those cases, I heard them for 20-something years. And the greatest thing was the dash cam, because people would say, well, I wasn't speeding, I never crossed the center line, they didn't have any probable cause to pull me over, they didn't have da-da-da-da-da. Usually in those circumstances they consented to a search because they're like the little kid who has candy and you say, did you take the candy off the table? No. Can I search your pocket? Sure. And then the candy's in the pocket. They don't think you're going to search the car to find, whatever's under the seat. And they give you consent. But know that the same expectations occur with the vehicle. It's just a different circumstance. It's a different circumstance. So to that degree, some additional food for thought for you to mull over and discuss, because anybody that's going into law enforcement in this region, you're going to deal with vehicles, and your stop issues are going to come as a result of that. That's it for week 3. I appreciate your efforts the first 3 weeks. It's going fast. We'll be at the halfway point next week. If you need me, you know where to find me.